right. We've addressed the order of presentation. We've addressed the various categories of exhibits from both parties. Because of the nature of one of the exhibits, we also addressed the issue regarding whether Attorney Headley will be a witness. She will not. She'll be the counsel for the department head. But the next matter is the testimony of any witnesses we call and opening statements. I apologize to the parties. The department will go first. Ms. Headley, do you have an opening statement for the commissioners?
Briefly, President Bach, thank you. Again, for the hearing, transcriber, Catherine Headley, Assistant City Attorney. Thank you and good morning. I appreciate your time and energies here and that you've already dedicated thus far to this appeal before you today. As the commission is well aware, the determination that you must make today is whether or not the separation from employment was reasonable. In this case, what I anticipate the testimony and evidence before you to show is that Mr. Young was hired to a position that he was not qualified for. The reason why he was not qualified for it is because he was not able to get proper security clearance through a federal policy and protocol that is necessary for him to access specific software that a subsect of the Office of the City Attorney uses. You'll hear the acronym or the initialism OED on a fairly regular basis. OED stands for the Ordinance Enforcement Division or Department. That is a small section of, or a smaller section of 8 attorneys, and about 4 support staff who work in the Police Administration Bureau, the PAB, another initialism for you. In order to gain access, unescorted access to the Police Administration Bureau, an individual must be able to pass a specific security clearance. That clearance, as you are now aware, is called CJIS, C-J-I-S. We use the acronym CJIS to describe that. There are 3 different tiers to the CJIS policy. Tier 1 is for folks who are able to access the electronic software that connects to federal databases that allows individuals to edit, access, and download information on people's driving records, criminal background histories, fugitive status, warrants, etc. In order to be able to access that, an individual must be able to pass a security clearance. And we'll get into more detail about that with our witnesses. However, and then there's 2nd tier and then a 3rd tier. The 3rd tier is to gain physical access to the building. In each one of those tiers, you would still need to be able to pass a background check. You would still need to be able to pass the policy's requirements to be able to gain access. Without that access, an individual is not allowed to have unescorted access into the building. So unqualification number 1, you cannot access the work location to do job functions without somebody letting him into the building, without somebody being present with him at all times. If work needed to be done outside of business hours, there's no way for him to have access these machines. Secondarily, a tier 1 access is specifically required to access, like I said, the justice system's databases. As you'll see on both job descriptions that are now in front of you, that was a key essential function of his job, is to be able to access the specific software necessary for OED to do its job. You'll also hear testimony that since Mr. Young's separation from employment, there have been ready changes to the software programs, and the person who is now in that position was able to access that and now facilitate more speedy delivery of relevant documents so that our OED, our Ordinance Enforcement Division, can prosecute municipal violations in a more timely, efficient, and relevant manner. To that end, I want to reiterate this has nothing to do with a previous termination by a previous administration. We have a new administration who reviewed this for the first time when provided an opportunity to do so. Realize that there's essential job functions that absolutely could not be performed by Mr. Young, and acted in the appropriate manner, which was to separate him from employment, again, to be clear, from non-disciplinary reasons. Thank you very much for your time.
Okay, thank you. I'm going to ask Attorney Hitchcock Cross if he would like to make an opening statement on behalf of the appellant, Mr. Young.
Thank you, and good morning, everybody. Thank you for your time here today. And I do appreciate the fact that you've gone through these lengthy piles of exhibits. Even just the policies in itself is impressive. Although I cannot let the chance go without underscoring something that my colleague just said. At the beginning of her speech, she said that it was not possible for my client to fulfill the functions of his job. At the end of her speech, she indicated that somebody else was fulfilling the job in a more speedy manner, more timely efforts. This statement completely undercuts their whole position and what we say ultimately is pretext. Either it's impossible for him to do his job or it's not. It's just like being pregnant. You can't do it halfway. And they've just admitted their central argument that Mr. Young was able to do his job, but they believe that he could have done it better. Well, that's not what they told you. Now, we do go back to the moment that somebody in the city attorney's office, again, that Robin Peterson, obtained my client's criminal record. And not just the summary, but the entire CGIS document, which is supposed to be protected. That document did not go to the city attorney's office. And Robin Peterson, who we believe is influential in this termination here, got together with Celia Jackson and went behind that city attorney's back to terminate my client. Now, there's evidence out there that the reason that Mr. Peterson did this is because he believes that the city attorney's office has information and other business that's too important for a criminal to be around. And that we submit is ultimately what this case is all about, is Robin Peterson's discrimination against conviction record. Because, as Ms. Headley told us, they know he can do the job. Because he did the job for 3.5 years. And that's the big thing that we all need to get around. Because we would expect, if the sky is going to fall in, just by my client doing his job, that in those 3.5 years, there would be some record of somebody in the police department stating that this was a problem. And in fact, the argument from my learned colleague over here was that the police department didn't make this decision. It was a new set of eyes. Well, not exactly a new set of eyes. but at least a new decision. Well, at least at this time, there was a decision maker. We can say that. So the second time, the do-over, they crossed their T's and dotted their I's to the extent that they at least got the person who was allowed to terminate my client to at least sign off on it. But the problem is that there's not any evidence out there to point to a different decision or a different reason than what the original decision was. The only evidence is they just waited their time, apparently, until there was a fresh set of eyes that they could freshly influence and make a new, fresh decision. But even here, it all comes down to the fact that they know my client can do the job, was doing the job, and that this is just a pretext. Because at no time have they stated why he was able to continue to do the job for 3.5 years. And that really is the question that's been raised here today that they need to answer. This is reasonable only if they can show that he couldn't have done his job for 3.5 years and that there was some new evidence here. The only evidence is the continued discrimination against my clients for non-felony convictions. I understood that it was the policy of the city, it's the policy of the mayor to give people second chances. And even when my client had a second chance, even when he performed the job to the satisfaction of everybody who mattered at that time, now, suddenly his work is not acceptable and he can certainly not perform the functions that he had been performing. That's not reasonable and he should be reinstated. Thank you.
President Bach, when you have a moment,
Yes.
I have just 3 things to bring to your attention. I need clarification, please, as which witnesses should be at this point allowed to hear this meeting. I just need clarification on that based on Attorney Cross's request.
The witnesses should not be listening to the testimony. The department has indicated that a management person from the police department will testify first, and that Deputy City Attorney Mary Shanning, who is their department's personnel officer, will testify second. That's what I understand we're going to do at the present time. If there are other persons, regardless of who called them or who requested them, those people should not be listening to the testimony. And we will hear from the police administrator, and then we'll give a call to Ms. Shanning and ask her to come over here to this building, and we'll take her next. That's where I think we left it, or where I left it with the 2 attorneys.
Okay. And then I also want to mention, you mentioned that Sharon Crow will need to be a witness per the list, but I do not have contact information for her or Tierman Spencer. And I did request that information this morning. I'm looking for email addresses. If Attorney Cross would be so kind to provide that, I'd be happy to invite them into the meeting.
If I may, this is Ben Hitchcock Cross in response to whoever speaking.
Yes,
I
sir.
did receive your email. I've asked my paralegal, Rondi Love, to facilitate that with you.
I have not received that information as of yet, just an FYI.
Thank you. I
You're
understand.
welcome. Mm-hmm.
Phone numbers as well.
Right.
Thank you, President Bach.
Do any of the Do any of the, at this time, do any of the commissioners wish to take a short break or not? Okay. We've had opening statements. The next step is the department will call its witnesses. And because of the concern raised by the attorney for the appellant, we are going to sequester our witnesses during the testimony of the others. And do we know if the manager from the police department
Yes.
is online?
Yes, he's on.
All right. The court reporter will swear in the witness. And the witness, first we'll start with him identifying his name and title, then we'll swear him in, and then we will begin the direct examination.
Thank you. Craig, if you could state your name and give your job title, please.
Sure. Good morning, Commissioners. My name is Craig Sarnow. That's C-R-A-I-G, S-A-R-N-O-W. I'm an Assistant Chief of Police with the Milwaukee Police Department.
May I proceed?
The court reporter will swear Mr. Sarno in.
Mr. Sarno, if you could raise your right hand, please. In the testimony you're about to give under the pains and penalties of, in the testimony you're about to give under the pains and penalties of perjury of the state of Wisconsin, do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Ms. Headley?
Thank you, President Bach. Assistant City Attorney Catherine Headley. Good morning, AC Sarno. Thank you for your patience this morning. Before we get into the kind of meat and potatoes, can you, for the commissioners, identify how long you've been with the department and your tenure with the department, please?
I've been with the Milwaukee Police Department for almost 26 and a half years. I have experience in all three bureaus of the department, that being the Patrol Bureau, the Criminal Investigation Bureau, and now the Admin Bureau. My current rank is Assistant Chief of Police. Prior to that, I was an Inspector of Police for 2 years. Prior to that, I was a Captain of Police, a Lieutenant, and then a Sergeant for 12 years prior to that. I currently oversee, as I said, the Administration Bureau, which includes 10 different divisions. Those divisions include facilities, IT, central booking, court administration, the Internal Affairs Division, just to name a few.
Thank you. As it relates to the job, your job with the Milwaukee Police Department for the last 26 years, can you just find for me the primary objective of the Milwaukee Police Department?
Sure. The Milwaukee Police Department is the largest law enforcement agency in the state of Wisconsin, and at its core is to protect and serve the citizens and the community for the city of Milwaukee.
Does that mission have partnerships with other various federal and state criminal justice partners?
Yes, in order for us to be effective at our jobs, we do need the collaboration, support, and partnerships with both local, state, and law enforcement agencies.
How many work locations are there for the Milwaukee Police Department?
We have 7 different districts that we have a footprint in throughout the city of Milwaukee. That includes the Police Administration Building, where I'm out of, and then our various other districts throughout the city of Milwaukee. I believe we have a footprint, though, in a total of 13 different buildings.
Can you describe for me, and I'm going to focus your attention now on the Police Administration Building, and if I use the term PAB, are you familiar with that being the Police Administration Building?
Yes.
Okay, can you describe for me what the PAB is and what it looks like?
The Police Administration Building is the building that's located at 749 West State Street. I guess, for lack of a better word, you would refer to it as police headquarters, because this is the main building. We have the first district, District 1, which is responsible for the downtown area, is on the on the second floor. That also includes the city attorney's office. On the third floor, you have Human Resources Division and Forensics. On the fourth floor is the Criminal Investigation Bureau, which includes homicide. On the fifth floor is the Central Booking Division. On the sixth floor is the Special Investigations Division, as well as the High Tech Unit. On the seventh floor is where the Executive Command Staff and OMAP is. And then on the very first floor is where the Municipal Court is.
Thank you. And in order to access any of those areas of the PAB, how does one access those areas? Can you define that for me?
Well, we do have certain floors, like the second floor is public access, and the third floor also has public access due to the forensics section being there. We have people that come up there for fingerprinting, but outside of that, outside of the first floor municipal court, outside of the second floor and part of the third floor, the rest of the floors are all restricted, which means you actually have to have you have to be authorized physical access to get onto those floors. And the only way you would go about getting physical access is to go through the process based on your role in order to get access.
And before we go any further, I noticed that you didn't identify any basement. Is there a basement at PAB?
Oh, there is a basement. It's referred to as the sub basement, but that's the parking garage where you find any number of vehicles parked.
And in order to access the basement, does one need to have a specialized clearance?
Yes.
Thank you. I want to turn now your attention to the tools that MPD uses generally. So earlier you identified that there's 3 different divisions of the Milwaukee Police Department: patrol, CIB, and administration. What kind of tools does an officer who's on patrol need to access on a daily basis?
Well, you would need access to various criminal databases for the purposes of conducting background checks on any given day. Officers in the field, have access to what we call the TRACS software, or TRACS application. That stands for Traffic and Criminal Software. That serves ours in the state of Wisconsin is referred to Badger TRACS because we have the Wisconsin version of that. This allows for immediate data entry in the squad car, more entry at a later time at the office regarding driver vehicle information and other forms. Officers also need network access to our report writing system, our Central Square or RMS or records management system for the purposes of filing criminal reports. They need access through any number of different platforms, as I said before, to conduct wanted checks on individuals for the purposes of background and, again, for the purposes for us to do our job to the best that we can do it.
And the same kind of question with CIB. Do they use similar software programs?
Yes.
How does one go about getting access to those software programs?
The first step in that process is they need to be granted access to the system. So they have to go through the application process, which is through our PL80, the sponsorship form.
Ms. Moore, would you be able to pull up Exhibit D1, please? D1. Excuse me?
We would just object to the rap sheet itself. This is going to go up on TV here. Part of this document contains my client's criminal history record. I believe that some of it's been redacted, but not all of it. So we would ask that care be taken when putting this over there.
Assistant Chief Sarno, can you see the document by chance or no?
I cannot.
Okay, just verifying. Thank you. All right, well, in the interim for, to make sure that we use our time here effectively,
Attorney Headley, what is the exhibit number? And I can just take a peek at it
D1.
before I share.
D1, I'm just looking at the first 2 pages of D1.
Okay, I need to know. Okay, I have redacted all personal information.
Again, just the first 2 pages of D1 is all I'm looking for now.
Just for the record, is it correct that there's no objection to the
No
first 2
objection.
pages?
Is that correct? Okay. Here's page 1.
Thank you. Assistant Chief Sarno, can you take a look at your screen and identify for me, is this the form that you were referring to about the sponsorship for access?
Yes, this is the Form PL80,
already got it. Go on.
Milwaukee Police Department
Thanks. I'm
sponsorship
listening, don't
request for,
Bye-bye.
did you hear me?
Yes, we can hear you fine.
Okay, Milwaukee Police Department sponsorship request for non-department personnel.
Okay. And obviously this is filled out, and we'll get back to this one in a particular second, but I just wanted to identify that this is the form that you were referring to as it relates to how one gets access to the physical location of the building, correct?
Correct.
All right, thank you. Ms. Moore, can you please pull up DU1? And while Ms. Moore is pulling that up, Assistant Chief Sarno, can you identify for me why the department has this form? The PL8E form?
Yeah, the form is, and it said on the top, it's a requirement for non-department personnel as it's part of our commitment to ensuring compliance with the Criminal Justice Information Services Security Policy, as we are subject to audit as a result of us being a law enforcement agency and needing to be in compliance with their policy.
Okay. Speaking of that policy, can you go ahead and take a look at the first page of DU1 for me? Recognizing
Yes.
that it is a very long policy, do you recognize this document?
Yeah, if you go back to the top, all the way to the main page, please. This is the Federal Bureau of Investigations CJIS security policy. It has a date on it of 2023. I do know that this particular policy that you have or you're showing me is a little out of date because they have recently updated it.
Can you, how do you know this to be the policy?
Because this is the policy that the FBI has posted on their website, and this is the policy that all law enforcement agencies are required to comply with as a result of the work that we do, and as a result of the audits that they do conduct on all law enforcement agencies, to include Milwaukee.
At this time, President Bach, I'd move DU1 into evidence.
Comment from Attorney Hitchcock Cross.
I mean, for what it's worth, the witness just said that this is not the definitive version or possibly even the operative version, but other than that, no.
Okay.
Well, the policy itself is, if I may speak on this.
You may.
I mean, the policy itself is a living document, commissioners, meaning that it's subject to change due to, emerging threats and evolving technology. So this was the policy that was in place in, as of version 914 of 23. And there have been several changes since then to the points that go to the points that I just made.
So to that point, Mr. AC Sarnow, can you tell me when CGIS was initially created?
Yeah, CGIS was created, I believe, in the early 90s. I want to say 1992, and their priorities are twofold. One is the management of the FBI's criminal justice information databases. Again, these databases that are crucial for us, for law enforcement in general, to make us effective at what we do. And then the second is protection. That's protection for the wide range of sensitive information related to criminal justice information, which is, again, you're going to hear a lot of acronyms, CJI, and the criminal history record information that includes both personal information as well as law enforcement specific records.
And just so I'm understanding, the commissioners understand correctly, in order for a person to have access to CGI, they need to be if they're not a law enforcement member, they need to be sponsored by the police department.
Yes, they need to be sponsored by the host agency.
Okay.
Because we're the ones that are ultimately responsible for everybody that accesses this information.
And who renders the decision as to whether or not the department will sponsor an individual?
Well, the decision is, comes as a result of doing the required checks that, the policy requires, such as the background check and all the things that go along with it. And I believe this policy, I believe it's under personal security, identifies the criteria that we use to weigh, to balance, whether or not someone gets access.
Certainly. Ms. Moore, could you please turn or navigate to page 168 of the PDF for the commissioners in front of you? That would be page 146 of the physical document itself, but the PDF, given the table of contents beforehand, is going to be 168.
President Bach, just for purposes of clarification, did we formally admit this as an exhibit?
Not yet.
Okay.
And it was concerned about
No.
whether or not it was actually an FBI document and who could verify that. This gentleman has done so. He's seems that he's indicated the policy comes from the 90s and that the one that we're looking at is a 2023, which may be slightly updated since then. That's what I got out of his testimony.
May I continue?
If you need to, sure.
Thank you. Assistant Chief Sarno, you should have the page up in front of you, 512, Policy Area Personnel Security. Is that what you were referring to?
Yes.
Okay. And what particular things does the department look at when determining whether to sponsor a non-department personnel member to have access to CGI?
I believe if you scroll down a little bit on this page, keep going, it's the next page then. Keep going. Oh, I'm sorry, go back up. We passed it up already. Go down again. We're almost there. Keep going, just a little bit more. That's point number 3. And that gets into if any record of any kind exists, access to CGI or criminal justice information, it shall not be granted until the designee reviews the matters to determine if access is appropriate. And then we get into what those records, what the universe of those records is. And that's
Sure.
a felony.
Go ahead.
And then they get into points A, B, and I believe it's C, yes, on what those records are.
Okay. So can I turn your attention to point B, the operative one in this case? Applicants with a record of misdemeanor offenses may be granted access if the CSO or his or her designee determines that the nature or severity of the misdemeanor offenses do not warrant disqualifications. The interface agency may request the CSO review a denial of access determination. The same procedure applies if the person is found to be a fugitive or has an arrest history without conviction. Did I read that section correctly?
Yes.
Right. Certainly, Commissioner Cleary, we are on page, if you are on the PDF, it's going to be page number 169.
Thank you so much.
Absolutely. I understand this is a very,
Far enough into-
so taking a look back at the case here, Mr. Young originally requested to have CGI access in 2022 pursuant to the first two pages again of D1, which Ms. Moore, if you can go back to, I would appreciate, just leave that one up where it is. I think that's probably best.
I'm sorry, could you repeat that, please? Where did you
Yeah,
want me to go?
D1 again.
D1?
Yes, ma'am.
Okay.
Ms. Moore, if you could scroll down, please, to the middle section where it indicates MPD network access tier 1. And scroll, okay, be a little further up in the middle of the page, please. You could go up just a little bit more, please. There you go,
That's
perfect.
it.
Thank you. Okay. Now, Chief Sarno, to be clear, you did not sign this document, correct?
Correct.
Who did?
Assistant Chief Nicole Wallner did. I was an inspector at the time, so I worked for Assistant Chief Wallner. Now I'm in the position that she was in. So if this document had come to me, if this document was filed today, it eventually would have came to me.
Okay. So taking a look at the center of this document, MPD access tier 1, tier 2, and tier 3, can you identify there for the commissioners, please, what those tiers mean?
Yeah, the tiers represent different levels of access, either access to various law enforcement databases or our own department network. In the first, in access tier 1, we see kind of a hashtag mirror Mary Lyle's access, and that access would be other. The box other is checked, and that's tracks and tracks amendments. Against tracks is traffic and criminal software programs and applications. Does not look like there's anything checked for access tier 2 as far as our MPD network access goes. And then if you get into, if you scroll down a little bit into access tier 3, that's the physical access, and that's the request is the same as other city attorneys at the PAB.
Certainly. And the decision and back in 2022 was what?
The boxes were checked denied.
When you became, and just to be clear, I don't know if we got this date out specifically, when did you become the assistant chief for the admin bureau?
January of 24.
Okay. Subsequent to your ascension to the assistant chief position in January of 2024, did you have the occasion to learn, did you, were you ever contacted by the city attorney's office about Mr. Young?
I was not. Oh, I'm sorry. Yes, I was. I was contacted, I believe it was in the fall of last year. I was contacted by Mary Shanning and Nick Desiato.
Okay. Did DCA Shanning and ask you to review Mr. Young's disqualification and his failure to get sponsorship for CJIS clearance in 2022?
Yes, they did.
Okay. Miss Moore, can you please bring up Exhibit A3? Thank you, Miss Moore. Assistant Chief Sarno, I'm going to draw your attention to a couple of these. I'll represent to you that this well, I'll ask the question. Is this a document that you reviewed or went through with DCA Shannon?
Yes,
Ms. Moore, can you please go to page 4 of the document?
I believe this is the objection here. I believe that this is the unredacted document. And I mean, even if it has an evidentiary value, I'm wondering what the benefit is to putting this CGI up on sharing it with the city of Milwaukee.
The benefit, if I can, I'm assuming that's an objection. I would indicate that this is already a part of the record, first and foremost. Secondly, it goes to the heart of whether Mr. Young was able to access the building and access the software necessary to do his job. And so this is part of the information that was considered in rendering that decision.
I think the assistant chief can say that. We don't have to go line by line through this.
I didn't intend to go line by line. I intended to focus on the ones that were of evidentiary value.
I think we could get by with, is this the document he reviewed at the time that he?
Certainly. Okay.
Let it go at that.
All right. DC, Assistant Chief Sarno, did you review Mr. Young's criminal background history?
I did.
Did you review that he was?
And now, ladies and gentlemen, after 4 months' vacation, we present to you the man the whole world is waiting to hear. New York, New York.
Who's on the air tonight, dear?
Jack Benny.
Oh, let's go to a movie.
Denver, Colorado.
Oh, Daddy, let's go see a picture show tonight.
Jack Benny is on the air.
I want to see Shirley Temple.
Glasgow, Indiana. Heather, who's on the radio tonight?
Jock Benny.
Well, it'll cost me money, but let's go to the movies. So now, ladies and gentlemen, we bring to you the man who has done more for moving pictures than any other comedian, Jack Benny.
Hey, Don, would you mind trying one more town?
Which one?
Oh, anyone. Say Waukegan, Illinois.
Okay. Waukegan, Illinois.
Who's on the air tonight, Mr. Benny?
My son, Jack. What a boy.
Oh, then you're not going to the movies tonight.
No, I saw the picture. Do you want me to tune in any other town?
No, Don, that's enough. Huh? Well, hello again. This is Jack Benny, who has just returned from his vacation, and I want to tell you, it's great to be back again. Back with this old gang of mine.
You mean me, Jack?
I sure do. Let's give Wilson a nice big hand. Yes, sir. But no kidding, Don, you look swell. Fit as a bass fiddle.
And now, ladies and gentlemen, we bring you a man who as a child had whooping cough, measles, and violin lessons, Jack Benny.
Hello again. This is not Jack Benny talking. So who do you think it is? Now guess. No. No. Give up? It's me.
J-E-L-L.
After you reviewed the document and in speaking with DCA or Deputy City Attorney Shannon, did you render a decision as to whether you would allow sponsorship of Mr. Young to have access to the building, PAB?
Yes, I did.
And what was that decision?
At the time, when we spoke, I said that had this come to me today with the same kind of record, I would have denied it and not allowed it to move forward through the process as well.
Can you identify for the commissioners why you rendered that decision?
Sure. The CJIS security policy and we already had kind of went over that personal security section, does allow for a waiver or a variance for misdemeanor offense. But due to the volume of misdemeanor offenses that this applicant had, this would not be somebody that, well, at the time, Assistant Chief Wallner, now me, would have allowed to move forward in the process because of the volume of charges that this individual had.
And that's just for the physical access of the building. And why did you make that decision there?
I'm sorry, you broke up.
Quite all right. So why is an issue for the police department to have access to their building?
Well, when you're talking about unescorted access, then this is an individual that, the department couldn't realistically allow to move forward in the process because of those charges for theft, because of the unescorted access, and because, frankly, this isn't somebody that we could trust to be in our building, be in our spaces, and to do the job that they're hard to do.
And when you viewed an individual's credit card, why did that determine for you that he could not have physical access to the building unescorted?
That particular one, the misappropriation using information, and then if you're given access to the various law enforcement platforms and databases where you're going to be getting information, and here was something that you were not only arrested for, but you were convicted for, to allow somebody to have access to that information with a record like this wasn't something that, again, we would allow to move forward in the process, nor request a waiver or a variance for.
Okay. Have you ever requested a waiver or variance for individuals with misdemeanor convictions?
I believe I have, and I believe that world was limited to a rather dated criminal damage to property or something like that, but never for.
And I want to touch upon just real quick too. You indicated that this is a living document. Did these standards that we had referred to back in the personnel policy and the CJIS, do those standards exist in 2022?
Yes, they did.
Do they exist still today?
Yes, they do.
We talked about what the policy is and what access, why individuals need access to the various software programs. Can you tell me what role the federal government has in reviewing whether or not local law